Today on the Corridors of Justice, you're listening to me, James Mabea, and this is Haki FM, the Oasis of Justice. You know how I do it right here. Miss Sandra Koech is here.
Hi Mabea. How have you been?
I'm good. What about you?
Salama sana. Glad to be back.
You're so welcome. You know,
Asante.
You're now our resident lawyer.
More than happy to be.
It's now 7 minutes past 5, and as I promised, we are looking at family law, intestate succession. And Miss Sandra, we could just start by letting the listener know what succession is.
Okay, the law of succession is the law that governs a person upon their demise or upon their death. So it's the law that takes care of their beneficiaries, their next of kins, and their estate. So that's the law of succession. Follows the death of a person.
Unajua hapa Afrika hatujazoea estate.
Yes.
Tunajua tu family and kin.
Yes.
Abroad, you hear, let's take an example of Michael Jackson. He died, and then you are told, or you read in the papers, that his estate will give something to Sijui akina nani.
Yes.
They will collect his incomes from music or everything he did.
Yes.
He does.
Yes.
So an estate, you can just expound on it. Yes.
An estate would include entirely the properties to the deceased. This could be movable property, so including monies, shares. And then immovable would include things like land. More of permanent features. So that would include estate. So anything that you own that it's legally under the name of the deceased, that constitutes estate. So intestate succession, I think our earlier discussion was on testate succession.
Yes.
Intestate then means where one passes on without a will, or where they had written a will and the will is declared invalid by a court, or where, for example, a will is, he writes a will, revokes it, and fails to write another will. So those are instances where you can have what we now call an intestate estate, where there is no particular mode of distribution that has been left by a deceased.
And what are these factors that make a will that was written, that is now when you die tested, and then the court invalidates it? What things make a will be invalidated?
A will be invalidated when we look at three main issues. So your capacity, the capacity of the testator in writing the will. So in capacity, we look at the age and the state of mind. Were they aware, were they legally sound in writing the will? So for example, if we find that they were suffering some sort of mental illness, some things like dementia, schizophrenia, such things would influence a court in declaring that he was not in the right capacity to write a will.
Coercion would be one?
Yes. Those are they're called they're vitiating factors to a will. So things like undue influence, things like coercion would constitute things, more or less the elements that the court will look into at invalidating a will.
You're listening to the Corridors of Justice right here on Haki FM, the Oasis of Justice. We are talking about intestate succession, which is a property owner dying without leaving a formal will. And a will in a... Maybe unaweza tukumbusha tu will. Nini iko pale kwenye will?
Okay.
The contents of a will.
Okay. So a will is a legal document written by a lawyer on the wishes of a testator. And the main clauses within a will that are very important is the distribution of properties, or what we call bequest. So this is where, first of all, the testator acknowledges the kind of properties that he has and the kind of and the mode of distribution that he prefers.
Right.
So he would list the different beneficiaries. This not need be family members. This could even be people he knew, like friends and everybody. That's the privilege that a testator has within a will. You can bequeath even someone within outside blood. So a will is just an instrument that more or less gives an executor or a named executor the powers to now distribute your estate, which now includes your properties, in a stated manner, in your manner, in how you'd wish. If I am to lay in peace, this is how I'd want Sandra to have my Porsche car. I would want my bear to have my Githunguri property. So that is a will. That is what a will gives you.
I like talking big. Hapo Githunguri ni nini inaweza kuwa huko?
Big property, vast lands in Githunguri.
Amen.
Yes.
Will ni kukufa na mpango.
Exactly.
Niliona a father died and then the sons just went to one of the wives and say wakagonga mlango and then wakafunguliwa mlango alafu wakauliza sasa mami kitu yote ya mzee sahi utupatie. Including remotes za TV. Jesus.
Oh my.
And kuna venye hata tu heshima inakosa pale.
Exactly, true.
Administration of intestate succession.
Yes.
There are different circumstances.
Yeah.
We start by where someone is unmarried. Kabisa.
So where they are married or have no children, there's a section within the law. This is particularly section number 39, section 39 of the Succession Act. So where the deceased dies intestate and with no children or no spouses.
Yes.
So the first persons to have the right to administer the estate is the deceased father. If the father is dead, then the mother. If both parents are dead, so the siblings come into play, both brothers and sisters, or the children of the deceased brothers and sisters. Yeah, and if that still doesn't, all the listed above are not there, then we go to half brothers and sisters. Yeah, and the children of this half brothers and sisters, if the half sisters and brothers are deceased. And then if all that list, if everybody, you do not have anyone in that list, then we go now to the what we call relatives of the 6th degree. So we now move into cousins, grandmother, and all that. If we can have no one to trust, to trace within this list, that hierarchy, it's a hierarchy.
We cannot trace the family tree.
Yes, we can't trace the family tree. Then the estate will be administered by a public trustee appointed by the government.
And that means?
What
entails a public trustee?
A public trustee, you see, for example, where you can't identify, or there's a family wrangles within an intestate estate.
Yes.
There are people within the office of the Attorney General who are named as public trustees. So where an estate cannot agree on a named administrator, or they cannot trace any of these relatives, a person, an official within the office of the AG, named a public trustee. There's an office of a public trustee within the AG office, the Sharia house,
All right.
They're appointed government officer. They are to now administer such estates, Yes, where there's no trace of any relatives to the deceased.
So how do they do it? They just go to the known properties of this deceased?
The known properties, most of this will become unclaimed assets. The assets recovery, most of it will stay. And that's why it's good to, make it known to people that these are my properties. This are my, that's why a will is very important. Name someone. If you more or less fell apart with your family, name someone, just a friend, a neighbor, just name someone who would get this. Otherwise, most of this will sit as unclaimed assets.
And then they will go to the government, and the government will make good use of them.
Yes, if you cannot claim it, that's why there's a time limit, I think, and I'm unsure about the years. But if anyone cannot come and claim, then it's relinquished.
So the government uses income from unclaimed assets as tax or something. What is this money used for? Because it cannot just lie idle there.
No, it will be used as just, you see, the way the budgetary you provide for expenditures. So this will be it will fall part of the basket.
Right.
Yes, that the government can explore now into the national budget. Yes, that is the kind of the direction that such unclaimed assets will take.
Msikilizaji, umesikia, if you like hiding your properties, you will start funding the Kenyan government.
Very true.
Okay, the public trustees have come in, they've taken your property, and then a relative shows up. what happens?
That's why I said it's unclear. It's unclear for me. I'm yet to confirm but there's a grace period. Yeah, a number of years. Yeah, they can't just take it up and be like tomorrow they're channeling it into different governmental boxes or whatever. So there's a time limitation within which a relative should come and claim.
And if they don't come or show up within that time frame, so that thing is just gone like that.
Yes.
Oh Lord.
Yeah.
That's so bad. Keep your suggestions, comments coming. I see Job Njagaranu. He is listening from Kikuyu. And Karoki Mbugua says, guest accolade, great discussion. Keep them coming on 0799387613.
Hii ni Haki FM, Oasis of Justice.
You're listening to The Corridors of Justice. I am Abea alongside
Sandra.
Oh, Sandra. You don't want to tell them the other name.
Sandra Kuski. That's the name.
You had it right there. So, intestate succession for a person who is married and the marriage was monogamous in nature. How does it happen?
All right. So, in such a case, there are two circumstances where they were married and had children at a monogamous setup, or they were married to one wife but had no children. So I will start with where they were married to one wife, a surviving spouse, and a child. So in such a circumstance, the surviving spouse will be named as the administrator. And she will enjoy some certain rights. The first right is that she will enjoy an absolute ownership over all the personal properties that belong to the deceased. Personal properties would mean things like your possessed items, like your watch, your set of jewelry, your furniture.
All right.
Yes, such things. So entirely that belongs to her. Yeah. But this, it should be noted, this does not include your trade of, for example, things that you acquired for your business or as a professional. Yeah. For example, if I acquire, if I build a business around hardware, that cannot be said to be personal possession.
Yes.
Yeah, your wife can't run to the guard and say, "Oh, this is all mine."
Yes.
Yes. So anything that forms part of the business or profession, something that you've built out of your profession, cannot be claimed to be personal household.
She doesn't get to inherit, or the kids doesn't have to get to inherit the academic papers.
I know. Those are yours. They're more or less joined to the hip with you. Yeah.
That one, you're going away. You go. It's like Manchester United fans. They're always living in past glory. You cannot apply for a job with your father's certificate. That's what we are trying to say.
Yes.
All right.
Okay.
Go ahead.
So when it comes, we've dealt with the issue of personal property. Now, when it comes to the net, we call it the net residuary estate. This is everything save for the personal items. Yeah. Now, this surviving spouse enjoys what we call a life interest. Yeah. Over this net residual estate. Yeah. And this estate this life interest only exists until her death. So, for example, if she passes on, it's a life interest. So it's dependent on her life. Yeah. So she enjoys that up to her death or upon her remarriage. So if she decides to remarry, she loses that life interest.
All right.
Yeah. And the life interest is for the benefit of the children. Yeah. So it's not for her to now dispose and move around enjoying the property. It's more or less to entrust. It's for interest of the children. So once she enjoys that life interest, she then enjoys the power to gift this estate, this residual estate to the children. If there are one child, that child will enjoy the intestate. If there are two or more, equal. She has the power to appoint equal. If one child feels like the mother, in exercising this life interest power, has misused it and has apportioned it unfairly, they can move to court and challenge her power to distribute. And the court can now revary that decision by the surviving spouse.
I'm so amazed at the fact that when the surviving individual is a lady and she decides to marry someone else,
yes,
that's it.
It's like for example, you're relinquishing this right because you marry into another family, and with that family, you assume that position of us as well. So if anything is to happen now to your new found love husband.
What if the marriage was monogamous, yes, but there was no official document showing that union was legal, but they had kids. But nobody can confirm that this lady indeed was married to this guy. What happens?
Now there comes, and that's why, for you to say you're in a monogamous marriage, it means it needs to be statutorily recognized. Yeah. So either a civil marriage, a Christian marriage, or a customary marriage. Yeah.
There's some people say the civil marriage, they're potentially polygamous.
No, a civil marriage is not. Yeah, there's no bigamy in civil marriage. One wife, one man. One man, yes, one husband, yeah. Polygamous opens the window. You can have more than one wife, yeah? Yeah, for customary, yes. So customary marriages, it's polygamous in nature, yeah? But there are some who choose to just marry customarily and just have one wife.
Yeah, so the best advice here is, legalize your union.
Yes, for sure.
We go for a polygamous marriage.
So now this becomes a little bit technical. For a polygamous marriage, the law of succession takes each house to be a unit. Okay? So for example, my bear, God forbid, you go to the white, you go see the man upstairs, yeah?
Yes.
You've left 3 of your wives,
all right.
Yeah? Each of your wife will be considered a unit, okay? And each house will be considered, so for example, wife number 1 has 1 child, or let's say 1 child, okay? So we shall follow the rules that I have given right now.
Right.
Yeah, where she enjoys absolute ownership over your personal properties.
All right.
Yeah, and the child, she'll exercise a life interest over the rest. But now, what happens is, for example, let's say you have an estate worth 40 million. You have 3 wives, okay? It will be divided equally, regardless of the situation of each child. If one had, but the court will be lenient towards each unit. For example, if one wife only has one child and the next has 10,
right.
It will be quite unfair to give equal, yeah? So the court will look at the nature of each unit, okay? So 40 million estate, yeah? You have 3 wives. It will be, if everything is fairly okay, each has maybe 2 to 3 2 children, 2 to 3, they'll get an equal share of the estate. So 40 divided by 3.
Right.
Yeah? Or let's say 4 wives, so 40 divided by 4.
So
each
10,
unit, 10. Then 10 million. Then within each unit, the court looks at the situation. Is it a surviving spouse with a child? Is it a surviving spouse with no child? Is it no spouse at all? Yeah. And then we shall look at now the different rules set under the succession law to govern that. So for example, let's say it's a wife with no children. Okay. The unit A was 1 wife with no child. Yeah. So what happens in that case? She will enjoy 1 wife with no children. She'll enjoy, more or less, she inherits everything because there's no descendant.
She gets her 10 million.
She gets her 10 million. Yeah. Number 2, household number 2, it was her and 2 children. It's now the scenario that we discussed prior. Yeah. She enjoys personal households, and then a life interest over this, and she distributes to her children immediately. It's not something that you distribute by will. She cannot sit and say, now my children, you'll get it after 10 years. No.
Especially when they are below 18.
No, below 18, what happens in such an estate, there needs to be a co-trustee. In such a unit, there needs to be 2 people. The surviving spouse and another to hold it in trust of the children.
All right.
Upon attaining the age of maturity, now it's the power, the gift is now bestowed upon them.
Right.
Yeah. And then let's talk about a house, maybe now unit number 3, where there was no surviving spouse. That's children. So these children will now enjoy that estate. Yeah. Equally. If there were 5 of them, equally. Yes. So those are the different scenarios. Yeah. But each house in a polygamous setup, they consider each house as a unit.
So let's say a monogamous marriage, and this guy had another child or children. I don't want to say outside wedlock, but let's say they were dating, they bore a child with a girlfriend, never married, but settled with another lady in a monogamous nature of a marriage. Is this child factored in when this property owner died intestate?
Yes.
As long as they can confirm that it is indeed his child, biological child.
Yes. Oh, definitely. The issue of illegitimacy does not work within the law of succession.
All right.
As long as if we have to go through paternity and prove that this is your child, he need not prove that you were even maintaining him. He need not even prove that he knew him. As long as it's shown that this is biologically your child, he becomes a dependent. And what happens most of the case, they will appoint the mother of the child to be a trustee, like a co-administrator for purposes of the child, not for the woman to get money. It's just for the purposes. The woman
is out of question.
Out of question. Actually, the new amendment to the law of succession made it very clearly. This new, there was this era where people would just show up. Me, I lived with this mzee.
The mumaba.
And you have their, me, I'm a wife. Me, I'm a wife. No, the new amendment made it very clear that a spouse is only one who's recognized under the Marriage Act.
All right.
Yes.
And the same goes for polygamous marriage, where 4 wives, like we gave an example of 4 wives, but another child or children existing that were not part of this polygamous marriage.
Yes.
So they are also factored in. Yeah?
They will be considered as a unit.
And what happens is, what will happen to the other one? Only the kids are considered again. Yes. Not the...
Let me tell you something. The laws of intestacy are very... How can I say? They embrace or they favor bloodlines. So spouses are the ones who get it rough. So for someone who's saying, oh, I've been living with this for 5 years, where's your marriage certificate? But people who can show direct bloodlines to the deceased are very much considered. They are taken care of under the laws of intestacy.
We shift the scenario now. We've been imagining it's the man dying.
Yes.
So what if it's a lady that has died intestate without no valid or no one will, and she was unmarried? What happens to her property or properties?
Unmarried?
An unmarried
with no children?
lady, no children, no nothing.
Remember the scenario where I said they will look into the hierarchy of
father, mom, siblings, half brothers, and if
Exactly.
there's nobody, then we go for the public trustee.
Exactly.
And you said people within the office of the Attorney General.
Yes,
Oh, Jesus, I'm a good student.
Yes.
What about an unmarried lady with no children?
Unmarried with no children? That is the situation.
Oh, no. Unmarried but had a child. Automatically it goes to the child.
Exactly.
Then she is married but no child.
Married with no child?
Yeah.
The
dies
husband,
intestate.
surviving spouse. The surviving spouse, the widower. The law does not recognize, spouse means husband stroke wife. Exactly.
I saw you smiling.
I see you have reservations with that one.
I'm not going to say it loud on air. Keep your comments coming around 7993876613. Haki FM 1 on Twitter, Haki FM 1 Instagram, Facebook, Haki FM 1 as well. We have a fan page, Haki FM 1 word.
Hii ni Haki FM, Oasis of Justice.
James Yandak, stays in Kenya, was born in South Sudan. Haki FM loves you, and you're tuning in from Kikuyu. Thank you so much. Keep listening and tell them about us. We are broadcasting on hakifm.or.ke. Unaenda tu pale mtandao, and then when you enter that and press go, it brings you to an interface that iko already, and then you just click play, and that's just it. Ni simple evil. Job Jogaranu says great discussion, lots of insights and uncomfortable truth. Maybe you could just let us know which uncomfortable truth that one is. But I know men are so happy with a lady dying, a lady they are married to dying, no child, and then now they have to, Kuna mmoja wetu hapa, sitasema jina yake, anasema siku hizi men are lazy.
Mabaya.
And they're also looking for mamas that have money. What say you?
Pardon?
What say you about that? Do you think it's true?
I think laziness is a choice. I don't think it's affiliated to men or women. You just choose to be lazy, not work hard. Yeah.
This is how I motivate people to love work. Work is the only way you get to enjoy the pleasures of life.
Hii ni Haki FM, Oasis of Justice.
You're listening to The Corridors of Justice. I am Abea, and I have Miss
Sandra Koskei.
And we're talking about intestate succession. So, as in, picture this scenario. A man dies intestate, doesn't name widow or the lady that was the wife as next of kin. Legally, it's the widow that is to inherit the properties. But in things to do with insurance, you remember when I was telling you we'll look at insurances, just any form of insurance cover, stuff to do with money, mobile money, balances like M-Pesa.
Yes.
Ulikufa ukacha M-Pesa pale, ama Airtel money, ama shares in companies. These do not recognize the widow if she wasn't named next of kin. Unaona, hata kama kulikuwa na marriage certificate,
yes.
The union was legal, but huyu mwanaume never mentioned the lady as next of kin. Yeah, it becomes difficult. So what happens in such cases?
Okay, so you see, things, for example, to do with life insurance policies, pension funds, and other instruments that require nominations, these are not covered within the law of intestacy. These properties devolve per the nominees. So, for example, in your pension fund, you said if I'm to die before my, when I can access my pension monies, I name Mabea, I name Sandra. Even if you have, other relatives, they cannot come start claiming over this, because this is outside the laws of intestacy. So this will go directly. The pension funds will be released to Mabea and Sandra. Life policies as well. But things to do with bank balances and shares, these are covered within the net estate, which now is subject to the laws of intestacy.
All right.
Okay. So normally for the laws of intestacy, other than applying this mode of distribution as per the laws of succession, the family members have the liberty of discussing and preparing what we call a schedule of distribution. So as you submit your papers to court, you agree that X and X, being shares held at Safaricom PLC, will be issued to to the wife. My monies, the account balances at Absa Bank, will go to my first daughter, Sandra. So what happens with intestacy? As much as there are laws, the beneficiaries, the people who are called as heirs and next of kin, have the liberty of discussing and sitting down and presenting to court a distribution list. And what happens once you present that to court? The court calls all the listed beneficiaries to court, and they ask you, mmekubaliana, mmekubali hii schedule vile mmesema hizi account balances iende Sandra, hii shares iko Safaricom iende Mabea? Munasema ndio. Na consent, there needs to be a signed consent of all the beneficiaries. So those form part of the net estate that will be distributed according to the distribution plan agreed by the beneficiaries.
So yes. And to avoid all this, the preparation of a schedule of submission and all that, we can advise the listener to keep on refreshing their data. Come, sometimes now I'm single, I have shares somewhere. Nimeweka next of kin sistangu.
Oh, very true, very true.
Or nimetoa nikaweka rafiki yangu.
Yeah.
Then I get married. Then I forget to refresh that.
Do you know that happens? That is what happens. Many people forget to change their next of kins, and you end up having children, and they're left out of such big estates. Such big, provisions that could help them with their schooling and everything. Yeah. So very true. You need to make sure you keep any nominations that you've made, either in your life insurance policies, under your pension funds. If you have children within this time, in the next maybe 5 to 10 years, update your next of kins.
Kabisa, msikilizaji, umesikia. If you die intestate, now hauna next of kin, then a schedule of submission by the closest family members.
Yes.
Wanaangalia the blood tree. Inaitwaje? Bloodline.
Yes.
Yeah. And then mambo yanakuwa sorted kama. Now, if you fail to agree, what happens?
The court will look at a fair and just and equitable distribution. Yeah. So there are times, let me tell you, curious, something very, very, very common that happens in court.
Go ahead.
You go, for example, there are 5 children. You go make a distribution of list. One child doesn't get anything. There are courts that reject that distribution. They ask for this last child. They ask for number 5, and the last child.
What about number 5?
Yes, why have you not provided for him? Yeah, and in such a case, they will tell you, go back
and
make a distribution that is fair and equitable.
And factor in.
Yes.
And hata ukiangalia tu, how does one end up in court with a schedule of submission that does not factor in everything?
Unless and when
maybe
the other party, the fifth, let's say the fifth child, voluntarily consents that there are people who they don't want to be part of this family. There are people maybe they've made money, they are living abroad. Okay, whatever is there, please just have.
They don't want
but they need to appear in court and make that representation in court, and the court will assess whether this person is actually in the right seat. Why would you deny property? So it's something that has to be subjected to the court's evaluation.
Another scenario of when a man is married, bears 2 children. And let's say child 1 is called A, and the other child is child B. And these kids grow, they become of age. Then later on, the wife dies. He remarries. And then this lady that has been married comes into the marriage with another kid, 1 kid. So that is child C. With time, the man passes on. But before that, he had a child with the lady. So 4 children in total. The first 2 with the first wife who died, and then the man remarried. The lady came with a child C, and then they had a child D, and then, life has it that we don't live forever. So 4 kids are left behind. He dies intestate. How is succession conducted with respect to child A and B, the children of the first wife?
Their children. So for them, they'll be taken, for example, so it's in an intestate succession, yeah? So what they will look at, it will be the first scenario where we discussed, where there's a surviving surviving spouse, because there's this second wife who's come in and is now a wife. So it is a scenario where there's a surviving spouse and children. Okay? For the children, for the biological children, it's a matter of right. Now, the surviving spouse will enjoy what we call remember what I said? A surviving life interest over the estate, the innate estate of this deceased man.
Right.
Okay? For this other child, now the one who was brought into the marriage, yeah? Now, for this particular one, still deserves provision, yeah? But it's a little bit different. For this ones, they need to show maintenance. This is a stepchild. This is not a biological child.
And the stepchild also gets to inherit property from the other previous marriage if the guy died there.
Yes, he didn't relinquish his birthright there.
Oh, Lord,
he still remains. Oh my God! A person, even a child is even a man of 40 years. There's a case where a man grew. He left his father. Then people were saying, "Oh, you're 50 years." The court recognized him as a child. Doesn't even if you go about your life, gain access to property, your own monies and everything, you remain a child. So if in relation to the other family, he remains a child to his father.
So this boy or girl gets to inherit twice.
Lucky she or he.
Then that's just it. There's this place where you mentioned the net residual estate.
Yes.
In the case of child A and B, the biological kids of the man. You said for the surviving spouse, it ends when she decides to get married again.
Yes, either when she dies or when she remarries. Yeah? And now when she dies or remarries, the life interest is more or less, it dies with her.
So what about kids? Kid A and B, does it end when they get married, or for children it's different?
You see, what happens when I say the life interest, it's like a power that you hold. Okay, for example, she's taken all the personal effects. Yeah, she's enjoyed the furnitures, the nice embellishments in the house. So what is left is what she enjoyed. She's like a power to just oversee. Okay, and with overseeing comes the power to bequeath the children. So child A and B will receive what we call bequest. Now it's for her to say, I give child A 10% of this estate. I give child B 20%. Child C, who is now from another, she has that power. But I told you, this power is to be exercised in a fair and just manner. If one of the 4 children feels that the mother has misused this power, they can go to court and ask the court to vary her provisions, yeah, and ask for court to now give them sufficient or reasonable provision. Yeah. So a surviving spouse enjoys a lot of power, but it's something that is vetted by the court. For example, even with this surviving interest, if she wants to sell, for example, some immovable property, yeah, she needs to either get the consent of all the children, or if there's a minor, have a trustee of the minor consent, or with an order of court. So she cannot go, this life interest is vetted. You see, she just goes about selling properties and everything. It's a life interest that is overseen by court at some instances where it comes to immovable property, yeah, or where she makes unjust provisions to the children, yeah. If she makes unfair apportionments to the children, it's overseen by court. So it's a life interest she enjoys till her death or remarriage. If she decides to know, I'm tired of this family, I want to go. Now, everything but before then, she must have distributed. Because I told you, this is not something that she'd say, I'd give you in 10 years. Yes. No, it's something that it takes with immediate effect. So upon getting the succession letters, she now has the power to now bequeath immediately. It's not something that she can bequeath in a will or in future. It's something that takes immediate effect.
All right, you've heard it from the amazing, the beautiful and knowledgeable, well-learned, not knowledgeable, Miss Sandra Kosgei.
Yes.
And maybe you could just tell them where you want to access, for legal services.
Okay. I work with the firm of Irungu Kangata. We are located at Upper Hill, 4th floor, Flamingo Towers. And yes, if you ever want to get some legal help, I practice both family succession, litigation, commercial practice as well, real estate as well. So you can always come in, visit me at Flamingo Towers, and just ask for Sandra. They can always find me there.
Thank you so much for keeping us company. And it means time's up. And we get to do this tomorrow again. Until then, take care.